Welcome to EUPrivacyForAll, Session 29 on GDPR, Article 14 on the information of data subjects. The information of data subjects was really a key debate. How much information should be provided? How should it be provided? European Parliament first added lots of provisions, such as security, data retention, transfers framing, for instance when it is to be framed by appropriate safeguards of Article 42, profiling, the logic involved in the automated processing, it was not retained, and then any further information, in particular if a high risk was identified by a data protection impact assessment. Also, a set of provisions was dealing with whenever a data subject would have personal data processed without providing it directly to the controller. It was then transformed by EU Council in Article 14a. On its side, EU Council added the wording that collection of data should be the moment when the data subject would be informed, at the time when personal data are obtained. It also added the fact that identity of the controller and contact details of the data protection officer should be provided, adding the legal basis to the information on the purpose of the processing and the legitimate interest whenever this is a legal ground used. Recipients, if third parties are receiving data, transfers to third countries, and the right to restriction and to portability. Finally, they added what is already laid down in the directive, that is to say, whenever the data to provide is mandatory or not, and the possible consequences of not providing data. Article 14 on the information to be provided where the data are collected from the data subject makes clear that most of the provisions proposed by European Parliament and Council were retained. The following information should be provided: the identity and contact details of the controller, but also the one of the data protection officer, if any, the purposes of the processing, the legitimate interests whenever this is a legal ground, the recipients, the transfers, and the existence of adequacy or suitable safeguards depending on the cases. Moreover, a set of additional information should be provided also at the time when personal data are obtained to ensure fair and transparent processing. It is more specific than the set of data mentioned in the first paragraph. That is to say, the period for which the personal data will be stored, or the criteria used to determine such a period, the existence of the right to request, access, rectify, erase, restrict the access, object, and the right to data portability, the right to withdraw consent at any time, the right to lodge a complaint, and finally, two specific provisions on the fact that the information is required because of a statutory or contractual requirement, and whether there are consequences if not providing data, and the existence of automated decision-making, including profiling. Also, it is specified that the controller intending to further process the data for a different purpose than the one mentioned when initially collecting the data should inform the data subject prior to processing for a different purpose. Finally, whenever the information is already at the disposal of the data subject, such information shall not be shared. Other key provisions in recitals 30, 48, 49 and 50 could be looked at. For instance, in recital 30, the lawful and fair and transparent processing make really clear that the information provided should be easily accessible, easy to understand, and written in a clear and plain language. Data subjects should also be made aware on risks, rules, safeguards, and rights at the time of the collection. Recital 48 and 49 stress one time more the points made in Article 14. Recital 50 recalls that in 3 cases the information shall not be provided to the data subject: whenever he already possesses such an information, when it is let down by law, or when it proves impossible or involves disproportionate efforts. Article 52(1)(a)(d) also makes clear that supervisory authority should contribute to the information of data subject concerning the exercise of their rights. Let's mention here that in Session 31, the way information should be provided will be fully detailed. In the directive currently, Article 10 frames the information in cases of collection of data from the data subject. So, at least, the information provided should be identity of the controller, purposes, and any further information, such as recipients, replies to the question being mandatory or not, and the existence of the right of access and the right to rectify the data. However, this is to be done insofar as such information is necessary to guarantee fair processing in respect of the data subject. What should accountable data controllers get prepared for? First, inform data subject of any further processing that was not initially mentioned. Second, provide information in an easily accessible, easy to understand and clear language. Overall, to make them aware of the risks, rules, safeguards and rights. It is an obligation that will not apply in 3 cases: when data subjects already have the information, when it is let down by law, or when it proves impossible or involves disproportionate efforts. If applying, the set of information to be provided includes the identity and contact details of the controller and of the data protection officer if any, the purposes and legal basis of the processing, legitimate interests in case it is a legal ground, recipients if there are any additional, transfers if any, and any further information necessary to ensure fair and transparent processing. So what will be interesting now is knowing more about the concrete implementation of this right and its readability.